Welcome to the liquidation module. So in this first podcast, I'm going to give you an introduction to liquidation. So here we're looking at the final installment of the processes that a company in financial distress can go through. So recall that receivership is an interesting mix of legislative rules and contractual arrangements between a company and a lender who has security over a company's property. When a company faces insolvency, the company may choose to go down the route of liquidation. Or it may be that the creditors choose to apply to the court to have the company placed in liquidation. Or you may have the situation where a company simply chooses to end its activities through a decision made by the board in cooperation with the shareholders, and the company closes down even though there's no question about whether or not the company can pay its debts. So liquidation can arise in a number of ways. It is regulated by the legislation, so the Corporations Act, and essentially liquidation can only occur through the legislative process. So we're going to be looking at the Corporations Act, some parts in that, and also again Schedule 2 of the Corporations Act, and also the Insolvency Practice Rules of 2016 are also applicable. So what do we mean by liquidation? We use the terms liquidation and winding up interchangeably. So I guess the book, which is really the Bible on the law of liquidation, is Macpherson's Law of Company Liquidation, written by Justice Macpherson. And I put that up on your PowerPoint. So this author explains liquidation as a process where the company's assets are collected, its property sold, the debts owed to the creditors are paid as far as possible, along with the costs of the process of liquidation, and then any surplus, if it exists, is distributed amongst the company's members. So liquidation is a process. It isn't just one step. So a series of things have to happen, and at the end of that process, the company is deregistered. So nothing is left at the end of the liquidation process, unlike with receivership and voluntary administration, where the company can continue to exist. We've already learnt that. So a company can be deregistered without even going through the liquidation process in certain circumstances. Deregistration is a final step that comes at the end of the liquidation process if a company is being wound up. So whilst the liquidation process goes on, the company, so the separate legal entity, remains in existence. The final step of liquidation, or also known as winding up, is deregistration, and that wipes the company off the ASIC register, and then the company ceases to exist. I'd like you to consider Section 601, capital A, capital C of the Corporations Act, which allows for the deregistration of a company which has been through liquidation. So in Chapter 5, capital A, point 1 of the Corporations Act, have a look at that. It's headed Deregistration. So ASIC has a direct power to liquidate a company. The operative section is Section 489, capital E, capital A. ASIC has been given this power to allow for companies that are sitting there not operating, so they're stagnant, to be deregistered. So ASIC can force the process of liquidation to enable the employees to access the government fund for employee entitlements. This covers narrow circumstances, what I'm talking about specifically here, but I just wanted to note it here, and we won't then cover this in any detail. Okay, So our starting point is to begin with the explanation that there are different types of liquidation. So the first is voluntary liquidation, and the second is court-ordered winding up. Okay, so two broad categories that you need to understand. For voluntary liquidation, there are two types. The first is members' voluntary winding up, which is where the company is solvent, that is, it's able to pay its debts, and situations where it's insolvent. So if we have a situation where the company is insolvent, that is, unable to pay its debts, it's known as a creditor's voluntary winding up. So we'll talk about both. For court-ordered winding up, there's a similar division as you can see on the PowerPoint diagram. You can have court-ordered winding up in relation to insolvency, and then also in relation to other grounds. And we will work our way through each of these, and you will find the details are quite similar. It's just how they commence is very different. Okay, so you will need to understand this diagram and keep these categories in your mind as we go along. Okay, Part 5.4 of the Corporations Act is where you'll find compulsory winding up in insolvency. Part 5.4 capital A contains the other grounds for compulsory winding up. We won't spend much time on the other grounds in this unit, but have a look at section 461, which is the key section which sets out the basis upon which the court will order winding up on grounds other than insolvency. It includes grounds like oppression, or if the members pass a special resolution to have the company wound up, and there is a just and equitable ground as well. When you look at that section, you'll see that. So usually in that circumstance, when you're looking at the just and equitable ground, we're looking at situations where there's some immense difficulty with the company. So for example, a company where everything is split 50-50 between two parties or directors or shareholders, and they have a falling out, so the company just can't operate. Now regarding voluntary liquidation, there is, as we've said, members' voluntary liquidation, which is where the company is in fact able to pay its debts. And then, as I've already said, there's creditors' voluntary winding up, and that's where the company isn't able to pay its debts. Now, in each case, you do need a member's special resolution. Remember, the definition of that is in section 9, to wind up the company. So the members get a say every time in voluntary liquidation. We'll come to this. Okay. So court-ordered winding up, also called compulsory winding up in insolvency, is covered in section 459 capital A through to section 459 capital T of the Corporations Act. So go and have a look at those sections. The starting point is section 459 capital A, which says that on an application under section 459 capital P, the court may order that an insolvent company be wound up in insolvency. One of the things to note here is that to be able to apply to the court to have a company wound up under section 459 capital A, you need to come within section 459 capital P. That is, only people who have standing under section 459 capital P can apply to have the company wound up in insolvency. These are people who essentially have some economic stake in the company. And these applications are usually made by creditors. Now also, when you have a look at the sections, note the word may. So the court isn't obliged to make an order. In other words, even if you establish that the company is insolvent, it doesn't automatically follow that the court will make an order for winding up every time. But it's only in very unusual cases where the court will refuse to make an order for winding up. The other section that's available for compulsory winding up, so court-ordered winding up, is section 459 capital B, which provides that the court can order the winding up of a company if there's some other litigation going on and it becomes clear to the court that the company is insolvent. Also remember that if there is an oppression action on foot, then this could reveal that the company is in fact insolvent and the court might order the winding up of the company. Also, under section 464, if ASIC is investigating a company, they may become aware of a company's insolvency and the court can then order the company's compulsory winding up. But normally it's done through section 459 capital A. So, as I said, under section 459 capital A, only those people who come within section 459 capital B have standing to apply to the court for the company to be compulsorily wound up in insolvency. Any one or more of the following can apply to the court. Okay, so the company itself, a creditor, what's called a contributor. So a contributory is essentially a member of the company. In Chapter 5 of the Corporations Act, the term contributory is used rather than a member because as well as current members, past members from the last 12 months can be asked to contribute in the event that the company becomes insolvent if there are unpaid amounts owing on shares. It can also include a director, ASIC, a liquidator or a provisional liquidator. You might say, given that you're applying for liquidation, why would a liquidator already be in place? Well, you can have a liquidator appointed under voluntary liquidation, so this liquidator may be applying here. Okay, so if you're moving from a voluntary liquidation to a compulsory liquidation. A provisional liquidator is a person put in place temporarily whilst the court decides, usually, whether to order the liquidation or not. Okay, sorry, I've just skipped moving on to this slide, so we've just covered this slide as well. So these are the people who have standing under section 459 capital B. Go and have a look at the list. Okay, now another important provision is section 95 capital A of the Corporations Act, which provides the definition of insolvency. So subsection 1 says a person is solvent if and only if the person is able to pay all the person's debts, and here we mean company, so the word person's used, but it actually is company. It's a legal person, isn't it? So subsection 1 says a company or person, legal person, is solvent if and only if the person is able to pay all the person's debts as and when they become due and payable. And subsection 2 says a person who is not solvent is insolvent. Now there is a difference between due and payable. Is there a difference between due and payable? The courts have actually said no, it just means the debts are due. So if your debt is due, That means it's payable and that you must pay it at that time that it's due. Okay. There are numerous cases on the question of what is meant by insolvency. The case on which this definition is based, found in section 95 capital A, comes from that last case on your PowerPoint, Sandel and Porter. Okay, so Chief Justice Barwick in this case used the line that a person is solvent if they are able to pay all their debts when they become due and payable. So in Sandel and Porter, the court said that when you're looking at solvency, so when you're looking at a company's solvency, you take a broad approach. You look at all the liabilities and assets. You look at when all the liabilities are due for payment and any funds which a company could raise in time to meet those debts. So for example, by mortgaging property. So the company doesn't need to have cash, for example, sitting in the bank waiting to pay its debts. This is reinforced in the other cases on your PowerPoint as well. So you need to take into account any arrangements which the company has with third parties, and that comes from Duncan and Commissioner of Taxation. In Lewis and Duran, the court also said that you do take into account whether or not there are other companies in, for example, the corporate group that would be willing to lend to the company to assist it meeting its debts when they fall due. So in summary, the Section 95 capital A test requires you to determine the company's existing debts, its debts in the near future, the date each will be due for payment, the company's present and expected cash resources, and the date each item will be received. So then the court needs to determine whether the company is suffering from a temporary lack of liquidity, in which case it isn't insolvent. Okay, so the solvency test is what's called a cash flow test rather than a balance sheet test. Now, a balance sheet test would be what are your assets and your liabilities, and if your assets exceed your liabilities, then you're solvent. This isn't the test that we apply here, because the problem with it is that it doesn't necessarily take into account when those liabilities are due, does it? So for example, a debt which shows up as a liability will often be able to be paid up over time on the basis of, for example, a loan agreement. So a company may not be able to pay, for example, the liability of, say, a $1 million mortgage, but over the period of the actual loan, which could be, 20 years, it can. So the balance sheet test also doesn't take into consideration how easily you may be able to sell some assets and not others. So the test in the Corporations Act that links into the Section 95 capital A is the cash flow test. So we're applying a cash flow test when we're determining whether or not a company is solvent or insolvent. Can the company meet the debts when they are due and payable, which simply, as we've already said, means when they are due? This doesn't mean that the court never takes into account the assets and the liabilities of the company. The court will consider if there are big liabilities that are going to fall due soon. If this is the case, then it might be very clear that the company will not have assets available to meet those debts as they fall due. Whether or not a company is solvent is a question of fact, and it's decided on the balance of probabilities. One thing to be conscious of is that a company can lack liquidity temporarily and still be able to pay its debts when they fall due. So for example, a cheque could bounce because there isn't enough money sitting in an account, but that money could be put into the account if there's knowledge of the lack of funds. So if that's the situation, then the company wouldn't be actually insolvent. The court has regard, as I've said before, to the broader picture to determine if the company is solvent or insolvent. They will have regard, or the court will have regard to commercial realities. For example, if directors are trying to be, say, optimistic and have completely unrealistic views about what could be raised in terms of money in a specific time frame. So the court will obviously question this. The court will take account of funds which can be gained from borrowings secured on assets of third parties or even unsecured borrowings. If you're a creditor and you're saying to the court, I think this company is insolvent and it should be wound up, it can of course be difficult for a creditor to prove the company's insolvency. This is because, as I've said, you have to look at the company's financial position as a whole, don't you? And you may be only one of thousands of creditors. So you may not, as an outsider, be in the position to prove to the company, to prove to the court that the company's overall financial position is hopeless. All you know, as an outsider creditor, is that the company is not paying your particular debt. So it can become an expensive process for a creditor if they're going to have to try to put all of this evidence together. So because of this, the legislation creates pathways for creditors to establish what's called a presumption of insolvency, which then puts the onus back on the company to show that it's in fact solvent and can pay its debts when they fall due. So these presumptions that I'm about to talk about are very important. So, Section 459 capital C of the Corporations Act, and in particular subsection 2, provides these presumptions. So subsection 2 says that the court must presume that a company is insolvent if during or after the 3 months ending on the day when the application was made, the company meets any of the requirements listed in section 459 capital C, subsection 2, paragraphs A through to F. So you need to go and look at that. The courts have interpreted this to mean that if any of the events listed in these paragraphs occurs, then you have 3 months to make the application to the court for the company's winding up. That is, the creditor has that, and to create this presumption of insolvency so that you can rely on it. Okay, so it's the creditor that's relying on the presumption, isn't it? For example, Section 459 capital C, subsection 2, paragraph C, provides the following presumption. Okay, so and this is the second point on your PowerPoint. So where a receiver of property of the company was appointed after a power contained in an instrument relating to a circulating security interest on such property. Okay. So in other words, if a receiver has been appointed within the last 3 months, the creditor can go to court and use that to trigger the presumption of insolvency. Remember that receivership is a separate process, isn't it? And if you have a company in receivership, it may not be in liquidation. Now, the most important presumption under section 459 capital C subsection 2 is where a company has failed to comply with a statutory demand. So this is the most important one. Section 459, capital C, subsection 2, paragraph A. If a company has failed to comply with a statutory demand in the last 3 months, then that creates a presumption of insolvency, which can be used as the basis for seeking to have the company wound up in insolvency. Okay. So now I'd like you, when you have time, to move on to the next podcast, which looks at that statutory demand process. Thank you for listening.